Dear students, we have the guests from far away, from United States, Charlotte Law School members of the Faculty of Law. This is Tony Ketron, professor, and Christensen. Yeah, they can say a few words in Lithuanian, but they are very excited about the trip here because we established the connection. We established the possibilities of cooperation and development of exchange programs. So maybe you'll be excited to know that next summer we are launching the summer program, which will be recognized by American Bar Association, and this program will be held in Old Vilnius University. And 5-6 people from the Faculty of Law, Lithuanian students, will be able to join the program. This is a very exciting opportunity for you. But today we have our professors talking about American legal system, introduction of course, but I think you will notice that there are interesting differences between our two systems, and the professors will explain you maybe more detail about this. So please welcome on stage Professor Ketron and Professor Christensen.
Thank you very much. Well, we're thrilled to be here. We're looking forward, as Dean Davalos said, to the program together. And I guess without further ado, we're just going to give a short introductory talk with you about the American legal system and legal education. If at any time you have a question or would like something explained further, raise your hand, signal you want to ask a question. And we would like this to be a conversation, so anything you want to know about the topic we're talking about, feel free to weigh in.
So we'll do a little bit of basics on US law, where it comes from, a little bit of how the government is structured. We can even talk about how it's a little bit different than Lithuania. And then a little bit about the differences between civil and common law. Since when you're here, you're studying in a civil law system, and we use a slightly different way of interpreting the law generally. And then we'll talk about what legal education looks like, because even the structure of how you become a lawyer and if you're licensed to practice, where you can practice and what you can do is different in the United States. So to give that kind of broad overview. And so my first slide is just a really big map of the United States, right? Because United States, we're all okay. So it's important, I think, at the beginning, in order to understand kind of how the legal system is built, to have some general contexts about the country in which it's supposed to operate. So here, we have 50 states, right? Any idea which one is closest in size to Lithuania? There's one that is like within like 1,000 square kilometers, like fairly close in size. No, New York could hold several. New York could hold all of the Baltics with room to spare. It's here. West Virginia is just slightly larger than than the nation of Lithuania. If you were to leave from West Virginia and drive west, as if you were in Vilnius, how far do you think you'd get before you hit Lisbon? So from Vilnius all the way to Portugal. If you're in the car, right? Can we imagine how many days that takes? Vilnius all the way to Portugal? Yeah, where do we stop? How far west do we get?
Keep going, keep going, keep going. Did anybody say stop? In the Pacific Ocean? Somewhere in Hawaii?
To leave from Vilnius and get all the way to Portugal, you'd end up somewhere between Arizona and New Mexico. And so we still have quite a bit of the country on both sides. And so it's, when we have to design a legal system, when we talk about what US law means, we have a couple different layers of law, considerably more layers of law than Lithuania does, because each state is going to have its own set of laws. And to be a lawyer, if I'm licensed to practice or Tony's licensed to practice, we are not licensed to practice in the United States. When we're licensed to practice, we're licensed only within one of our various 50 states.
Or you can be licensed in multiple states, but you would have to qualify for that license individually. So to be licensed to practice throughout the United States, you would have 50 jurisdictions you would have to qualify
50 different bar examinations, 50
waivers.
It would take, I don't know if anyone's actually ever mastered it, all 50 states.
Now, we, of course, are in North Carolina. Our law school is here. So the state of North Carolina essentially would regulate most of our graduates' admission to the practice of law, the ones that are going to practice in North Carolina. If you take law school in North Carolina, you don't have to practice there. You can practice in New York, you can practice in South Dakota, wherever you would like to practice. But that state's rules would determine your admission to the practice of law.
And here in North Carolina, so anyone been here in Vilnius for 1 or 2 Lithuanian winters? Right? So where we are in North Carolina, even in January, the weather can be like it is today. I think Tony has lived there, 10, 12 years, and it is never coldest he's ever experienced, -6.
Yeah, -6 the coldest. Some winters we get no snow, we get no ice. So if you like outdoor sports or outdoor activities, come visit us in Charlotte.
Now, if you want a Lithuanian winter, Minnesota's a great place to be, right? Where it can be -30, -40, and if you really like snow, we have parts of the Great Lakes, the lake effect snow, where you end up hitting. Oh, I don't know. They get 60 feet. They get 20, 30 meters a winter.
Of course, you're forgetting our fathers in the state, our fitness.
There's no law school in Alaska.
That's true.
You can't study law in Alaska.
Can't study law in Alaska.
You can be licensed to practice there. You can't study there. And so just a little bit kind of where we're from while we all teach here in North Carolina. America, we move around a lot, right? It's the same currency, it's the same language. So I'm from Northwest Ohio, I'm from here. And then in the last 10 years, I've lived Virginia, New Hampshire, Minnesota, Oregon, Arizona.
I'm from Tennessee and Maryland. I went to school in New York. I have worked in Michigan, Texas, Virginia, the District of Columbia, and of course now in North Carolina.
So we move around a lot, but if we're talking about the practice of law, we have to actually be licensed in one kind of place or jurisdiction.
This is a slide which basically talks about how our American government is structured. To understand the differences in our legal systems, I think it's best to start with the differences in governmental structure. And you will see that our federal government, which this slide represents, is broken into 3 branches. And the branches are co-equal in authority, but they have different spheres of authority. We have a legislative branch, that's the U.S. Congress, which makes the laws.
Samus, right?
Right, the Samus. You have the executive branch, which is the U.S. presidency, which executes the laws, enforces the laws, and has several, even under the cabinet vice president, there are several executive agencies and administrations. Probably the most famous that you guys are used to dealing with, the U.S. State Department, which runs our embassies worldwide, and diplomacy worldwide, works for the U.S. president, and the U.S. Department of Defense, the U.S. military, is essentially an executive agency, falls under the Secretary of Defense and the President. And then you have the judicial branch, which decides what the law is, interprets the law, and that's a lot different than in a civil system because of the common law. We're under a different legal system where we have a Latin principle called stare decisis, which essentially equates to judge-made law. And essentially taking a set of facts that aren't specified in the law anywhere and applying other legal principles to a set of facts, the judges, through case opinions, will essentially make law which needs to be followed in the future in similar cases and similar circumstances.
And lawyers, when executing the common law, so unlike the civil law where it's essentially written by the legislative branch, our courts are given a little bit more authority. So the common law allows them to go ahead and use principles of equity or fairness, principles of public policy, in order to articulate a version of public policy that then becomes the equivalent of the law. And so I've found in talking to a number of different Lithuanian audiences, one of my favorite examples comes from the world of property. So in the United States, we have a version of judge-made law that we stole from the UK, stole from Britain, and have enacted whereby if you go about taking a piece of land that someone else owns, right, and you put a fence around it and you call it your own, If you do that long enough, you win the property. It actually becomes yours. It's called adverse possession. And it comes from these principles that, you know, we're a huge country that at the very beginning, we didn't have very many people at all. So we didn't like the idea that someone could own a huge tract of land and not put it to any economic use. So not to, you know, farm from it or you know, build a factory or build houses. And so in order to limit the ability of a landowner to own land that had, but to not, who didn't use it economically, our courts decided that if someone moved onto that land, fenced it off and called it their own, well, they begin to have a property interest in that land. That it serves the interests of the country, even though it may infringe on the interests of the landowner. That at some point, simply by fencing off the property, you're able to go to a court and say, I'd like the title to the property. I'd like the government to recognize that I'm the legal owner because I'm putting it to use in a way that the former owner, you know, doesn't or never has.
In a way, this arises from our history as a nation with the westward expansion. There was one time a lot of abandoned land, so this principle became very useful in dealing with those issues. Somebody would move on maybe to the west, left their property, left their land, didn't account for it with legal title, that sort of thing. Adverse possession is a way to deal with those type of issues.
And so even now, there are, you know, last year there were more than 5,000 published judicial opinions about the principle of adverse possession. Sometimes there are people arguing over gardens or driveways, but sometimes there are people arguing over huge tracts of many square kilometers that are used for, you know, farming or agriculture or mining. And the courts go ahead and legally transfer the title with no payment required to the person who's actually using the land. And you wouldn't find a decision like that in the civil law system, right? The civil law system is very clear in terms of land ownership. A judge could not substitute these versions of public policy in order to transfer the ownership of a piece of land from one person to another. And so our courts are given that added discretion. Adverse possession is just one of many, many examples where courts substitute their judgment where the legislative body or the elected body of government has not promulgated rules that prohibit them from doing so. So we have whatever a law that arises, right? The system is more or less the same. It's passed by our legislative branch, then it has to be signed by the executive branch in order for it to come into force. But unlike Lithuania, how many people sit in the Seimas? We're all Lithuanians. We all took government. If the American knows this and you don't, this is sad. How many people sit in the Seimas?
141.
141 sit in the Seimas, right? And how are they elected? So is the country divided up into 141 districts and there's a representative from each of them? No? How's it divided?
They all are elected.
Proportional majority.
There is 70 seats in the Seimas are elected by proportional representation, right? So when you vote for a party. 71 seats are elected how? It's not all strictly proportional. "71 seats in the Seimas are actually divided up into legislative districts, right? Lithuania is divided up and you vote for a representative from your region or from your district. And so then you get 141 total representatives. And when they agree, when that body agrees, right, law is then passed to the president and it becomes the law of the country. The Seimas is just one legislative chamber. We have two different legislative chambers. So in order to make law, or where the origin of law comes from in the United States, it has to be approved by both legislative chambers of government. And we call those legislative chambers the Senate and the House of Representatives. And so much like the Seimas is divided into individual member districts, 71 districts, and also a version of proportional representation, we have something fairly similar. So our House of Representatives divides the United States up into 435 districts. We're a much larger country, we have much bigger districts, right? So and each district elects one person. So a more populous state, a place like New York or California, has a lot more representatives in the House of Representatives than little states like Rhode Island that you can barely see here on the map.
Which would have two.
Or really big states like Wyoming, where Wyoming is about a little bit smaller than Germany, but nobody lives there. Like 600,000 people lives there.
Rocky Mountains, it's mountains.
Right. I mean, yeah. It's
beautiful.
It's beautiful, but nobody lives there.
You vacation there.
As a result, even though the state is very large, right? Even though it occupies a very large landmass, since it has very few people in the House of Representatives, it gets only one of those 435 voices. And so, our other legislative body is the Senate. Does anyone know how the Senate works? Anyone study American government? No? So, our Senate is a little bit like the proportional representation in that every state, no matter how many people are there, gets 2 votes. So the Senate, we have 50 states. Every state gets 2 people. There are 100 senators. So it doesn't matter if you're from Wyoming, where there's fewer people than live in Vilnius, or if you're from California, where there is more people than live in Spain. They get the same votes. Everyone gets 2. And in order to go ahead and create law, any piece of legislation in the United States has to be approved by both chambers. So it has to be approved by the chamber where every state is given equal votes, and it has to be approved by the chamber where states vote according to their population.
There was a dispute when we adopted our Constitution about whether you favor the rights of the individual voters, which are based in the House of Representatives, representing the people, or whether you look after states' rights. At the time the Constitution was written, the senators were appointed by the governors of the states, as opposed to being directly elected by the voters. Now, through constitutional amendment, that has changed, but you still have the idea of representation benefiting the states themselves, every state having 2, versus the purely population-based proportional representation in the House of Representatives, kind of the direct representatives of the people. So it's that passing in both chambers that essentially looks after the interest of our federalistic system, the states themselves, and also the voters that reside in the states.
And then when we talk about our judicial branch, here in Lithuania you have 2 different highest courts, right? The Constitutional Court, which goes ahead and hears complaints or disputes regarding the meaning of the Constitution of the country, and the Supreme Court of Lithuania, which goes ahead and hears a lot of the criminal kind of disputes, right, that appeals from the trial courts around the country. And the one doesn't review the judgments of the other, right? A Constitutional Court does not go ahead and, unless some action of the Supreme Court is alleged to violate a constitutional principle, they don't go ahead and review the decisions of the other court. In the US, we've combined those functions. We have a single Supreme Court who acts as both the Constitutional Court and the Supreme Court of the country. So we have a single body that goes ahead and can articulate the meaning of the US Constitution and the meaning of federal laws. And so in this judicial body, we have our general structure of the courts are that we have a trial court, and then there's an intermediate appellate court, and then the Supreme Court can review the decisions of those intermediate appellate courts. And so our Supreme Court is handed about 5,000 or 6,000 cases a year. Right, it's a fairly large country. We have 310 million people. And the number of disputes that trickle up to the Supreme Court is large. They decide about 100 or so. They decide, they can refuse to decide cases that are brought to them. So they only decide the most important legal questions in a given year. So they decide somewhere between 80 and 100 cases each year.
Now they also have a few cases which come to them as a matter of original action. So things like disputes among states, they will be the initial court in the chain. They're not reviewing lower courts' opinions and those, limited types of original actions before the court. So there'll be a few of those each year. So say New York, New Jersey have a dispute over who owns a certain piece of territory between the states. That would be something that would come directly the Supreme Court.
And so if you want to think about that in the European context, it would be, you know, if Latvia and Lithuania have a dispute, or Lithuania and Poland have a dispute, well, who ought to be the final or highest arbiter? Should those cases start in the local courts of either country? And in the way the EU is set up, right, they don't. There is an EU body that a dispute between one state against another state, one country against another country, begins solely in those EU courts, because it would be unfair to allow the dispute, you know, between Lithuania and Poland to begin in Polish local court or Lithuanian local court. There would be too much pressure to go ahead and you know, find for your government against the opposing government. And so it's the same in the US. We don't allow a dispute between you know, New York and California to be heard in either New York or California. That dispute would begin in our Supreme Court, the body that would be entrusted to resolve cases between the states themselves.
And what makes this very complicated, I guess, is you replicate this governmental structure not only on the federal level, you know, for the entire United States dealing with national issues, but we also have what we referenced to and why we showed you the US map earlier, the 50 state governments. And at the state level, you also have a similar version.
We have a state legislature,
right?
A state governor, the president of a state is a governor, and then a state court system.
Yes, and so you have essentially two court systems, legislatures with, you know, responsibility for state law within their boundaries, and then of course the Congress for the federal laws, and then of course the governor or the chief executive at the federal level, the president. So we have these, you know, simultaneously running systems of government that are similar, but they run at different levels at the same time. And so they respect the rights of each other. A lot of our Constitution is about the boundary of those rights between what states can do and what the federal government, of course, can do. And the structure, as we've hinted at, is intended to represent those interests, or at one time was intended to represent those interests in some way. And it plays out in the legal system and the court system, as we'll soon see.
And because these branches of government are responsible for creating the law, it's also interesting to know kind of how you become a member. So we do a lot more voting than Lithuania does. While our federal judges are appointed, most of our state judges, even sometimes our state Supreme Court, is elected by the people.
Of the voters.
And so you'll have debates between, you know, individual lawyers that want to sit on the Supreme Court of the state about, you know, what is the meaning of the state constitution. You know, are they going to interpret it to be harsher on criminals? You know, are they more lenient towards business? And so when we go into the voting booth, you know, there are times that we end up voting on, you know, 30, 40 different offices. We'll elect, not only cast a vote for the President of the United States and our, you know, senator and our member of the House of Representatives, but then we'll also vote for the governor of our state, and a member of our state House of Representatives, and a member of our state Senate, and members of our state court system. So we have a lot, and then our city mayor, right, is the executive branch. Many of our large cities like New York have their own legislative branches, right? There are 100 persons that go ahead and are part of the New York City Council. And so, you know, you'd have to elect members of the city council as well. And so it's a little bit more directly representative, and there are a lot more layers of where law comes from, because it can come from our city, from the county the city is in, from the state that city and county are in, and then from the federal government. And so as a lawyer, you need to be cognizant of or aware of the laws at each of those different levels in order to go ahead and represent your clients.
And I think we may have a slide on this, but the laws work within their own spheres, but also affect the other spheres. So for instance, there might be federal highway dollars, if we're talking about transportation, to create a federal system of roads throughout the country. And that might be tied to state law, because to acquire those funds, the states will be required to have you know, certain laws in place, certain things at the state level, and then of course from those laws are derived local laws that implement those. They can work in the other direction as well. So oftentimes there's this blending which judges are forced to interpret as they apply the law in the common law system as to, you know, who is responsible, what law applies, and how that affects the individual citizens that are before the court. Let's take a look at some of those slides.
Yep.
Here's what we're referring to otherwise. When we talk about the federalistic system kind of creating a dual system of law, here you see the U.S. Supreme Court as the ultimate arbiter of U.S. law, you know, deciding what the law is, and you see different chains into the Supreme Court for a case that may emanate in the federal system going through U.S. district courts, the lowest level of trial court, and of course going through the first level Court of Appeals, U.S. Court of Appeals, into the Supreme Court, which is the final decision-making authority of all matters, you know, for instance, constitutional law or other federal legal issues. We also have issues that come to the Supreme Court from the state court system. So for instance, somebody's convicted of murder and may receive the death penalty. Some of our states have the death penalty under their state law. They may receive the death penalty for that murder conviction. It would, of course, go through the state courts of appeal system and ultimately be analyzed by the U.S. Supreme Court. Those lawyers would ask for, you know, for cert before the Supreme Court, would ask the Supreme Court to consider whether the application of the death penalty was constitutional under the U.S. Constitution in that case, and the Supreme Court would ultimately review and could review that case and decide whether or not the death penalty was constitutional.
And so this dual system is set up in a way that if you're an individual who commits a wrongful or an illegal act, that act could be illegal both it could violate a federal law, right, passed by our federal Congress and signed by the president. That same action could violate a state law passed by the state government and signed by the governor. And you would be subject to penalty by both the state and the federal government in separate trials. So you could go ahead and for that action, be tried for breaking the federal law in one place and be tried again for breaking the state law in a different place, because they are different sovereigns, right? They're different sources from which law emanates. And so if you're in the US, you think, well, I should only be tried once, right? We even have this provision called double jeopardy that says the federal government can't try you twice for the same crime, or the state government can't try you twice for the same crime. But the state can prosecute, and if they fail to get a conviction, if that action was also illegal under federal law, the federal government could re-prosecute you for that action. And so you potentially could serve time both in a federal prison facility, you get out of the federal prison facility, you know, leave the prison, get picked up again, and tried and held in a state prison facility for the same action. So different sources of law and where they come from. Are you good?
I think we're good.
All right. So
Yeah,
this
go ahead.
Yeah, go ahead.
I just say, we talked earlier about kind of the overlap or the spheres of influence of the federalistic system and how the Constitution sets that up.
When he says federalist system, he means a system of shared power between the federal government and the states. The notion that each of them make their own laws.
Yeah.
So.
And in our constitutional system, essentially, you know, powers not affirmatively granted by the document to the federal government are reserved to the state. So essentially you have two spheres of influence, but as we suggested earlier, there are places where there's overlap. And so, for instance, state governments and the national government both get to raise taxes. So we may have taxes as American citizens, as citizens of the town of Charlotte. We pay taxes there. We would have taxes that we owe, you know, every year to our state government, you know, where the state carries out its governmental functions and, you know, in running the state government. And we also pay taxes to our federalistic system. So both states and the federal government can raise taxes, provide for the public welfare, criminal justice. Professor Christensen talked about that. You have essentially the ability to charge in both systems in the criminal system. Some things, however, are reserved to one of the other spheres by the Constitution. So it is our federal government, for instance, that you deal with at the embassy that does our diplomacy and our international relations. It is, of course, our federal government that worries about foreign trade, that worries about national defense. The state government, what's a little different, is predominantly responsible for the educational system. So state departments of education, public schools are essentially state schools. So state schools in Mississippi can be of different quality than North Carolina, although they're essentially run about the same. You'll have police forces at the local level. You don't have a national federal police that's the on-the-ground enforcer of law, although we do have a federal Bureau of Investigation, but those sort of things are generally state powers.
And then we leave to the federal government other responsibilities. So we don't have 50 different currencies, right? The federal government, we all use the American dollar. We don't have different postal systems, that the delivery of mail is regulated only by the federal government. And those powers, these powers that are explicitly delegated to the federal government come from the Constitution itself. So within the Constitution, it sets up or it gives the authority to the federal government to do a certain list of things. And then our 10th Amendment to the Constitution makes clear that if the authority to act is not explicitly given to the federal government, then everything else is left to the states. So for example, education, the authority to regulate education, nowhere in the document, the Constitution itself. And so every state runs its own educational system. They place different standards for high school graduation. They run public universities and charge different amounts of money, have different programs, have different standards through those systems.
Similar to legal matters, to be licensed in a state to teach, to be a public school teacher, you of course in North Carolina to teach there have to ultimately receive a North Carolina license. If you move to Virginia, you would have to have at some point a Virginia license to teach in the public schools.
And it's the same with law. In order to practice law in North Carolina, I have to have a North Carolina legal license. If I'm a North Carolina attorney, I can't just go to New York and be a lawyer. I have to get a new legal license. I have to sit for a new exam in that other state. And so it's one of the things that a lot of our students really struggle with when they get to law school. They may not know exactly where that job is going to be or where they want to work, and they have to make those decisions before they graduate, or they're going to end up taking several bar exams. And just like here in Lithuania, the bar exams are they're not fun. You don't do them, like, oh, it feels like a good day, I'm going to go take a bar exam. They take months in order to prepare for, and depending on what state you're in, they take as long as 3 solid days of sitting at 8 to 10 hours a day and taking the exam. So you have to really give some forethought in terms of where you want to practice law. A lot of people think, oh, I have a law degree from the US, so I can practice in the US. And that's true. A law degree gives you the authority to take the bar exam in any of the states. But an exam in one state does not give you the authority to represent people outside of that jurisdiction.
And in case Professor Christensen didn't mention it, they also charge a fee to sit for the exam, and they're very expensive. So running anywhere from a few $100 US to
a couple thousand,
$1,500 to sit. So you don't really want to, unless you're independently wealthy and you want to be the first person in the Guinness Book of Records to say you've taken all 50. Probably not the thing to do with your life. So.
Not the thing to do with your life.
All right, let's talk about legal education in the U.S. Kind of the reason we went over the governmental structure first is because that'll help explain, why we do what we do in legal education. The first point is what we've mentioned already, is that you have to be licensed in individual states. So I'm a North Carolina lawyer. I went to school in Virginia, at University of Virginia School of Law, got my degree from there. That gave me the ability, as Professor Christensen said, to take the bar in any of the 50 American states. I decided to begin my practice life as a lawyer in North Carolina, so I took North Carolina's bar. Now, I can't regularly practice law in the courts of Connecticut. I may be able to go up as a one-time, my clients hired me to attend court hearings or to conduct one trial as long as I associate myself with a Connecticut attorney. But if I want to regularly practice in the state of Connecticut, I'm going to have to become a member of Connecticut's bar to practice there, to represent my clients in court there.
One of the things that's really different is that a law degree in the United States, there's no bachelor's of law. So our graduates, our youngest students, are 22, 23 years old. So before you begin the study of law at all, you do a bachelor's degree in another discipline. And it doesn't matter to us what discipline. I have students that were art majors, right? Dance majors in college, English majors, history, political science, engineering, mathematics. You have to have a bachelor's degree before you begin the study of law.
So those math and dance students are some particularly good law school students. They really are.
And so that's why even our first degree in law is a doctorate. So if you come to the U.S., the ordinary first degree that our students would receive, they would do 4 years to earn a bachelor's degree in something other than law, in history, in political science, in education, in English, whatever. And then they would do 3 additional years of law study. And so at the end of 7 years, you have a Juris Doctorate or your doctorate in laws. And that is the first degree that licenses you or gives you the authority to practice law in the US. And so it's a very different system than you hear, right? So are some of you between the ages of 18 and 22? Anyone under the age of 22? So you wouldn't ordinarily be one of our law students. If you were in the US, you would all still be doing your bachelor's studies somewhere else. And so should you come and study, with us or with the United States in a study abroad program, be aware that they're going to think that you're a prodigy, right? You're 20 years old and studying law, to an American, that means that you must have gone through, you must be brilliant, right? Because you've moved very fast. And many of the other people in your classroom, if you're studying, with American law students, will be a couple years older than yourselves.
Or even older. We do have a lot of people who get their bachelor's degree, as older students, or get their bachelor's degree as a young student, work several years in a completely different career, and then decide they want to come into the practice of law. So if you were to exchange with us and come to our law school, you would have folks that range in age from 22 to the 60s. And so you'd have older folks that are maybe working out in the economy, doing other jobs at that time and taking law school courses. So it's pretty common in U.S. education, not necessarily to come straight through, from high school to bachelor's degree to law school.
And so that first degree, the Juris Doctorate degree, confers the ability to practice law. An LLM degree requires that you go ahead and you have training in law somewhere. So that can be here at Vilnius University, having completed a bachelor's degree in law. It can also be from the United States, having completed a Juris Doctorate. But the master's degree, the LLM degree, is an additional, it's ordinarily about 1 year of training. And there are a number of different ways in which that LLM program is structured, and that's the next slide. But it presumes some knowledge of the law. So you could finish bachelor's studies here, even master's studies here, and do an LLM in the United States. You could do a Juris Doctorate and then do an LLM in the US. But it requires that you have some kind of training in the law to begin with.
I will say this, there are generally 2 types, or the LLM types fall into two camps.
Next slide.
No, this is a little
okay.
different. There are substantive LLMs, which are a specific area of the law, like tax law. And there are a lot of LLMs geared for folks who have foreign legal training, and that's essentially the next slide.
And then we do not offer a PhD in law. So that is not a degree that the United States recognizes or that American universities confer. Because even our first degree in law is a doctorate, right? Because it presumes 7 years of post-high school study. There is no equivalent to the PhD. Many of our professors will have just the Juris Doctorate degree and then a number of years of practice experience. For those students that really want to go ahead and get that kind of dissertation or thesis component, the United States curriculum offers an SJD, which is essentially the equivalent of a PhD in law. And it's based on 2 years or 3 years of additional law school classes in a US classroom, followed by 2 to 3 years of the preparation of a thesis and then a defense of that thesis.
A lot of times our judges will take such programs.
But they are not common for ordinary practitioners.
Right.
In fact, in the US, there are probably fewer than 50, 100 students a year in the whole country that finish something like an SJD program, because it's so much additional training that there's virtually no job that requires its completion.
All right, this slide talks about the licensed practice law. We've already made the first point. Every state has its own requirements, and the bar, usually the Supreme Court of that state, is the ultimate regulator of the practice of law within its own state. So one of the things that, if you come to the U.S. to practice law, it's a good idea, or you want to practice law in the United States, it's a good idea before you make your educational plans, before you make your travel plans to the United States, to get on the websites of each of the bars. So if you think you're interested in practicing in maybe New York and California, or North Carolina and South Carolina, find out what those requirements are from the bar, and then set your educational path, and make sure your educational path will match the requirements where you seek to get licensed.
Some states will require you to actually do a 3-year JD program, even though you've already done legal training here in your home country. Other states will allow you to sit for their bar exam if you complete certain requirements and an LLM program. And so that's why it's extra important you figure out where you want to practice, so that you know what kind of program you would need to look for in the US.
In most cases, a written bar exam is required, which Grant has described. It's essentially a combination of multiple choice questions. There's what's called a multi-state bar exam, which is law common to the federal system, the national system. And then, of course, each state will test, usually in a written essay type format, on its own state laws and principles, oftentimes focusing on the distinctions between that state's law and the federal law if there are common topics.
So that requires you to know the law of the state in which you're about to be licensed in. Yeah.
In addition, there are a few opportunities where you get the license from one state and you have practiced for a while. So you have 5 years of practice. Some states will allow you to do what's called waive into the bar of that state. So if you're already licensed in New York, you may also be able to, just as an example, waive into the bar if they have reciprocity of the bar of a state like Vermont or Connecticut. Of course, they require you to pay the additional $1,000, $1,500 fee and submit the background paperwork, but that's essentially what's required. You can sometimes get in that way. The District of Columbia, Washington, D.C., where a federal capital sits, has comity with a lot of states, and if you've already passed a state bar and are a member of the state bar, you can file the background check paperwork, the character and fitness paperwork, and become a member of the bar in Washington, D.C. Federal courts have their own admissions requirements. The first requirement, of course, is that you be licensed in one of the states. So you can't just go into the federal court system and practice without a state court license. So you have to pass the bar exam, or otherwise become a member of a state court bar. Once you pass that requirement, then you have to file paperwork with the federal court proving that you're a member of that bar in good standing, that you don't have any disciplinary issues, that you're a proper character and fitness and experience to practice before that federal court. And then finally, each state has its own requirements regarding the maintenance of your law license. So for instance, education is continuing in the American system. And I think you guys in Lithuania do that here. You have, after you become a lawyer, you'll essentially take courses to expand your knowledge, to refresh your knowledge in various substantive areas of the law. We expect that of American lawyers too. Every year they have to take a certain number of courses to maintain their law license. Of course, we don't want them getting into trouble as representatives of the court. We want them to be of upstanding character, and so the court expects those things to maintain their law license. Now, foreign students and U.S. law schools. We've already talked about the JD. That's the 3-year degree. So if you take a JD, and to get into a JD program, essentially you have to take a test called the Legal Scholastic Aptitude Test, which is called the LSAT, common phraseology. Score high enough on that. You have to have your undergrad work from somewhere. It can be from a foreign institution. And of course, you've got to show good character and fitness, and you have to apply. And then you'll be on a 3-year course of study in many cases. Now, as a foreign graduate of foreign law degree, you may be able to achieve something called advanced standing. In other words, some of the courses you have taken, say you come to the University of Charlotte and study at our School of Law for the full 3-year program, some of your courses, up to 30 credits, can count toward the JD. Depending on whether our registrar makes the decision that they're of equivalent level, remember that American law school is a doctorate level degree, not a bachelor's degree, that sort of thing. But some of your classes, like for instance, if you take contracts law at University of Vilnius, that class may count to satisfy the contracts law requirement at the American law school. And so you can get up to essentially a year's advanced standing with your foreign law school study. Another way that a lot of foreign educated lawyers come to study in America are through the LLM degrees that are geared toward American legal studies, helping you understand American law. Now, there are a couple reasons you may want this. One reason is a few states allow the LLM degree. For instance, New York is one of those states, will allow that LLM degree to become, if you have a qualifying foreign degree in the law, to become a pathway to admission without taking the JD degree. So you can study for a year in the United States and then sit for the bar if you meet the other requirements of the state of New York. California is another state. North Carolina doesn't allow that, but of course our law school can get you ready with the LLM degree we're offering next year for bar admission in these other states. But essentially, you may want to practice law in the United States. Say you have a job offer from a US firm or a US company to practice law. Secondly, you may want an LLM degree just to understand American law. As you guys know, the world is becoming more global. Us being here and benefiting from your hospitality and starting a program up here in Vilnius is an indication of kind of the globalization of law. Business is becoming the same way. And a lot of companies are looking for lawyers who are trained in other nations' law, who understand American law so the Lithuanian company can do business and establish relationships with American government, American industry, that sort of thing. So to have that credential can be important to your job practices, so for general knowledge of the U.S. law. So those are some of the advantages of earning an American law degree to give you that kind of understanding. I know we are NATO partners, our nations, increasingly becoming trading partners and tied together by common bonds of industry and commerce. And for those reasons, I think it's a really important vehicle to have an understanding of the law in our country is to take one of these degrees. Speaking primarily, and I'll just offer our programs as an example, there's a lot of flexibility, especially in our LLM program. We have 2 tracks. One is geared for practice of law in one of the jurisdictions that would allow it, that's New York. And it basically has prerequisites that would help you qualify to sit for the New York bar, assuming you met all the other criteria. We call that the New York track. You also have what's called a flexible track. So maybe you wanted to sit for another state's bar, one of the ones that allowed it, or you just simply, Charlotte's the 2nd largest banking center in the United States. Let's say you had a job with a US bank or a Lithuanian bank that did business in the United States, and you wanted an understanding of US banking regulations and banking law. So you could take a track designed by yourself in conjunction with our registrar to enable you to better understand banking regulations, commercial law, corporate law, things of that nature to better inform your own education.
And as we continue to move forward with the development of different opportunities, as Dean DeVoulis was mentioning at the beginning, next summer will be the first time that we'll be bringing a group of American law students here to Vilnius over the summer to study. And so we'll be here teaching some of the courses. We're going to borrow some of the members of the Faculty of Law here from Vilnius University to teach some of the courses. And this hopefully will be an annual thing that just gets bigger and bigger. And so it's not specifically reserved for our own students. It will be open to students from every law school in the US. So, from all 202 ABA accredited law schools, we'll take a cohort and bring them here to Vilnius to study. And then in conjunction with those classes, Vilnius University will be enrolling a number of Lithuanian students in those classes so that we have Lithuanian and American students taking international and comparative law courses together. And he will be, or the dean will be working on, what are the admissions requirements, the consideration requirements. He'll decide which Lithuanian students end up being enrolled in the program. But as a kind of an opportunity to begin thinking about, what does the common law look like? What is it like to study law in the US? We'll have an opportunity, or we'll have a number of American law students here in Vilnius so that you can have that kind of one-on-one interaction not just from our school, but from other American law schools, a little bit about what the study of law is like. So if that's something that is of interest to you, I encourage you to look out or communicate with the administration here at the Faculty of Law to figure out how they will kind of apportion those Lithuanian students in the classes. But it's an exciting opportunity, even just to have a group of 10, 20, 30 American law students here for a couple months and get to show them Vilnius and how beautiful it is, and the language and the culture, and for them to learn a little bit about the European Union. For many of them, it'll be their first time outside the United States. So it will be a really exciting opportunity to bring our two schools and our two countries kind of a little bit closer together. I think that's the last of our slides.
Any questions you guys have, on these topics that we've covered, or anything else, regarding American legal system study?
U.S. law generally?
Any questions you have regarding the systems that we haven't answered or you would like explored, we're happy to do so.
I have a question. First of all, thanks for a very interesting conversation. And well, I'm not so familiar with American law, but you told a lot about, like, it was a very good example, for example, international disputes between Poland and Lithuania, which law should be applied in this situation. For example, we have two parties in a case. One is from California, one is from New York.
Yes.
We go to Supreme Court as like impartial court, the third party, let's say this, and which law will be applied in this specific case? I mean, the law of California or law of New York, or maybe another one.
Yes. So.
Fair question.
Yeah.
Take it.
This is my area of scholarship: conflict of laws in the United States. So. I wish there was an easy answer for you, right? Like, it will always be California law because they're the bigger state. And if that was the answer, then I wouldn't have a job, because it would be, you just figure out what the state is bigger and you apply the law of that state. There are, first, our legal principles, because our judges are allowed to use kind of policy arguments as part of the common law. So the first thing they ask is, did the parties agree prior to the dispute to an area of law? So if I sign a contract, I'm from Ohio and Tony is from, Tennessee. If we sign a contract, if I include in the contract that disputes under this contract will be resolved by the laws of Ohio, and he agrees, he signs, right? Unless he can demonstrate that, he was under duress at the time, or, I fraudulently induced him to sign the contract, then he's bound by his promise. And so the way that we resolve those kind of commercial disputes is to include in the contract a choice of law provision. So that way, before there's any dispute, we mutually agree the law of state X is going to apply.
And the contracts will also often designate the forum as well. So they'll tell you which court system to regulate the disputes in.
Right. Like the dispute must be heard in, and sometimes they're strange, like the dispute must be heard in Tennessee, but the Tennessee court must apply Ohio law.
And the Tennessee judge would then, of course, have to
apply Ohio law. If it's not a contract dispute, so let's say we get into like a car accident, right? Did we, had anyone been in a car accident? Anyone negotiate, you don't negotiate with the other party prior, like, oh yeah, like next Tuesday, I'm gonna hit you on the highway, right? Can we agree in advance?
That's attempted murder, that's not a car accident.
The law of whatever state will apply. So in those kind of contexts, we have 50 different states. Every state's court is allowed to determine what choice of law provision they use. Our 50 states have selected 4 different choice of law methodologies. So, and which one applies is where the lawsuit was filed in. So even if the accident took place in New York, if the lawsuit gets filed in North Carolina, then to that dispute, North Carolina's choice of law rules will apply. And there are 4 different ways in which those choice of law rules exist. And that's, we teach a whole 3 credit hour semester long class on how you interpret what those are. And so I can't give you more than that, other than it's the law of the state where the lawsuit was filed. their choice of law rules determine what substantive law governs the dispute.
Which means that North Carolina may apply its choice of law rules and ultimately decide that New York is the best law to apply.
And so you end up being in a North Carolina courtroom, but arguing about the meaning of New York law.
That's
Sorry,
clear as mud.
this is one of the most complicated pieces of all of U.S. law. So
It's a common question to all legal systems.
Yeah.
So if you're concerned about the answer in the U.S., maybe we can.
yeah, I can give you if you have. We can continue to talk about it. It's very interesting to me how states pick their different methodologies.
And that's why the mediation will be common in the USA, because we do not have to deal with this court. It's much more convenient.
Well, mediation is probably pushed more than anything by the cost of litigation in the United States.
Lawyers are not cheap.
Lawyers are not cheap.
Yeah.
The time to bring cases in court, while the courts and state legislatures have struggled to have speedy trials and things of this nature, it can be slow. So you could have your auto accident in May of one year and not reach trial for 2 years later. And so 10 years, whatever, long period of time later. The witnesses may have passed on, they may have forgotten important facts. You've got to go through a whole discovery process about important documents and depositions of the witnesses, and then the appellate process on the back end of the trial. And so that's not cheap, it's not short. And so, arbitration, mediation, dispute resolution mechanisms are becoming increasingly popular, especially when you have the ability to set your relationships up ahead of time, a contractual agreement. So oftentimes, contractual agreements will say, we're going to arbitrate, they'll set forth the arbitration rules that'll apply, and they'll set forth the forum that the arbitration is to occur in. But you can still have litigation because, did the person understand what they were getting into, those sort of things.
It may be interesting that 97 out of every 100 cases that start in the court system finish before trial.
Or mediated, so.
Or are dismissed, or, there are only 3% of cases that begin the process actually reach like a courtroom with a verdict. 97% of cases are either settled between the parties or thrown out by the judge before they get to trial. And the settlement is strongly encouraged due to the cost of litigation.
Yeah, I'm not a criminal lawyer, but on the civil side, we have both the federal system and the state system. You have the discovery process, where essentially you're able to ask for the other side's documents and you're able to depose their witnesses and they're able to do the same thing to your side. And that process will often lead to settlement or dismissal because you find out more about the other side's case. When you're able to value the case.
When he says depose witnesses, he means that you're allowed to ask them questions under oath, so that if they lie, they've committed a separate crime.
Which is perjury.
Yeah, and so it creates a very strong incentive. You have to tell the truth or stay silent. And as a result, you can get some concessions, and very important evidence by being able to ask people that witnessed the event or participated in the event to ask them questions under oath. And so that process is called a deposition. I have no idea what the Lithuanian equivalent word is, but the English word is deposition.
It also has a role in preserving the evidence in case somebody were to die, and it keeps witnesses from telling different stories later on, because you can use their earlier words to bring them back to that version of the events. So it serves many purposes. It's a great question with long answers.
Sorry. We're law professors. You guys all have law professors, right? Sometimes
like
our
to talk.
answers are long. Yeah.
Any other questions? These are great.
I'd like to ask a question about the international law.
Sure.
Like now we see that a lot of turbulent events take place and the international law must quickly develop, must quickly respond to the processes in the Middle East, for example, the Arab Spring or the power shift from the west to the east and a growing danger of cyber warfare. So how is our international law look like now? Is it more common for everybody, or states are looking for some ad hoc solutions, trying to create solutions only serving their national interest?
Well, that's a great question. International law is what I teach, and so I'll take a shot at this one. That is an ongoing question in international law. In the United States, I'll speak to the view of international law in the United States. There are famous U.S. cases, one in particular called Paquete Habana, we were talking about this earlier, where a U.S. Supreme Court justice, in dealing with the seizure of fishing vessels off the coast of Cuba at the end of the Spanish-American War in the 1890s, essentially made the famous statement that international law is part of our law. And, you know, basically saying customary international law is a reliable source of U.S. law. And of course, if you were to look in our Constitution, you would see that treaties, you know, properly adopted under our constitutional system are listed at the same level as laws passed by the U.S. Congress.
Or the Constitution itself.
Yes, the Constitution itself, which sits at the top of the pinnacle. It's called our Supremacy Clause in the U.S. Constitution. So international law is supposed to be part and is adopted, going back to the founding of our nation, as part of U.S. law. One of the struggles of international law as a legal system is, in large part, is based on the principle of positivism, state choice. To get states to agree to submit to international law, they get to choose whether to be in a treaty. They, you know, can choose what practices to adopt in their state behavior, and that regulates whether they have adopted customary international law, whether they follow a practice or opt out of that practice as a matter of international legal obligation. Now, international law is kind of at a crossroads because there are some principles that we think don't come from the positivistic principle, like international human rights, that people have natural rights that go with the people. So we used not to care what Germany would do to its own citizens. We would care if Germany would abuse a Lithuanian citizen because that was an international incident. International law had a lot to say about that. But what Germany did to its own citizens, international law had little to say. Well, our view, you know, following the Holocaust and things of that nature have changed, okay? So we have international human rights law. We have, you know, the idea that, you know, in the UN Charter that you shouldn't mount aggressive warfare against another state, you know, that you're only allowed to use force when faced with armed attack as a measure of individual or collective self-defense. So international law is changing. In America, there is still a debate as to how much U.S. courts should rely upon international law. So if you were to track our U.S. Supreme Court justices, we have a wing of the Supreme Court, the more liberal justices, that often quote and rely upon international law in their decisions. For instance, the Roper case, which was talking about the execution of juveniles, you know, giving a death penalty to juveniles, and so there's some quotations regarding international law in that case. We have another wing of the Supreme Court that prefers more to rely, the more conservative justices prefer to rely on domestic law. I think the answer to your question is each individual state, the way the international legal system is set up, has to decide, and I hope they will decide to respect international law and work together for a more peaceful and just world. But the system is set up so each individual state is, through the positivistic principles in most areas, making those decisions. Now we see with several world issues, everything from nuclear armament to chemical weapons, you've got the situation playing out in Syria now. How much should other countries, either through the auspices of the United Nations and Security Council, or maybe, you know, other treaty vehicles, how much should they be responsible for enforcing international law? Can an individual sovereign state, you know, such as the United States in the Syrian situation, can it be responsible for being the enforcer of international law as it sees it? So, I mean, these are developing issues. I hope I've answered your question.
One of the difficulties we face is that the United States is very reluctant to sign up to a number of treaties.
Yes.
Right, so in order, the way our system works, in order to agree to be bound by international law, we need the president to sign the treaty, but then we need 2/3 of our Senate. So 2/3 of that body that are represented by the states to also agree to the treaty. So there are a number of international conventions to which our president has signed. Either, you know, President Clinton, George W. Bush, President Obama, they go ahead and they sign a treaty, but if the Senate refuses to ratify it, it's not legally binding upon our courts. So one of the struggles we face isn't as much a legal one as it is a political one. So we need our government to have the political will to make some of these international treaties binding obligations under the law of the United States. And until the President signs and the Senate ratifies a lot of these international legal principles, although you can always make an argument to our courts that they're part of customary law and need to be followed. You would have a much stronger case if the political branches would ratify the treaties. So that speaks to, you know, as much a political dilemma as it is a legal one.
Yeah, one particularly interesting issue in the U.S. legal system, it's also an issue in certain other legal systems, is even if we have ratified, our Senate has ratified a treaty, and under our supremacy clause it becomes part of the law, who gets the right to enforce that law through the U.S. court system? So we basically have treaties that are treated in two ways. You have self-executing treaties, which immediately give a person rights to bring an action in court, and you have non-self-executing treaties where our Congress has to pass an additional law to give effect to the rights agreed to on the international level by the U.S. federal government.
And if they don't pass
the law, then you would have no rights to come into court and say,
yeah,
you know, my personal rights have been violated because the U.S. or somebody else didn't honor this treaty. So there may be this additional layer requiring, you know, operation by the entire Congress, you know, to pass a law. It requires both houses of Congress plus the president to sign it into a law. It can get really complicated because you may need what is essentially the executing legislation to be passed for a treaty.
Other questions?
Yeah, anything else? Any topics?
Okay. Well, seeing none, thank you very much for coming out and participating today in a little bit about the U.S. law and where it comes from and what legal education in the U.S. looks like. You know, we're always available. You can find us. I don't have cards anymore. I forgot the little note card things. I left them back at the hotel. But we're Charlotte School of Law. We are not that, you guys are all internet savvy, right?
We are on the web. Our website address is simple. It's www.charlottelaw.edu, which stands for education website address in the U.S.
Right. So you can always find us that way.
You can find us there. Our programs will be described there, and hopefully we'll soon have something on the website about our cooperation agreement and our summer program here. And if nothing else, I say achoo, and we look forward to seeing you guys as we're walking around with, you know, our summer abroad program and our law school students from, you know, from America next year.
Come participate with us next year, absolutely. Thank you very much.
So, thank you.
Achoo.